And I hope our discussants will have an opportunity to respond to the presentations of our previous two speakers. Our first discussant is Professor Vito de LUCIA. Professor LUCIA is a professor of international law at UIT, the Arctic University of Norway, and director of the Norwegian Center for the Law of the Sea. His current research agenda focuses on ocean commons and BBNJ. During the negotiations, the BBNJ negotiations, he has been observer since 2016. He is author of the Ecosystem Approach in International Environmental Law, Genealogy and Biopolitics, and co-editor of International Law and Marine Areas Beyond National Jurisdiction. I have a feeling that Professor LUCIA will not pull his punches in his role as a discussant. Professor LUCIA, the floor is yours.
Thank you very much, Judge RHEE, for your kind introduction. And let me join those who preceded me in thanking and expressing my gratitude to the organizers for the generosity and for having honored me with invitation to speak here. And also, let me stress how impressed I am with the impeccable organization on this wonderful conference. I may also be spoiled now and know for future conferences, as Neil has expressed earlier. I don't have a presentation, so I will offer some views, some of which I prepared beforehand, some of which we'll pick up on, and I'm not sure it will be a response, but it will be maybe a comment and elaboration on some of the points that have been already mentioned. And so, and I will focus exclusively on the question of principles, so general principles and the role of, in particular, Article 7, and then maybe look into some of the content. But I wanted to, before I do that, I wanted to, this is a reaction to the first presentation where Kurt has highlighted that some tensions, one of which I want to pick up on, not to really elaborate much on it, but maybe to throw out a question for him and for the other panelists, and maybe also to the audience, and the tension between conservation and sustainable use. Now that's a tension I'm familiar with coming from an international environmental law background, so it's been a long-standing tension in the context of the Convention on Biological Diversity. I think it acquires an additional dimension in the law of the sea context because it elicits, at least to me, another tension with another conceptual pair, which is the conceptual pair contained in part 12, which is the protection and preservation of the marine environment. So there is a quadrilateral tension that we may, at one point, have to discuss. So having said that, and having thrown that out, which I think is quite an interesting question. So in relation to Article 7, which has already been discussed in some detail by both speakers, and I think maybe the first remark is to echo what Kentaro said, that there is quite a non-systematic provision which contains a somewhat disparate set of principles, approaches. Some may be characterized as concepts, some of which are very old and traditional to the law of the sea, some very many centuries old. Some are fairly established principles or concept of international environmental law. Polluter pays principle, precaution, whether that is a principle or an approach, let's leave that question. The ecosystem approach, which is, in my view, more a concept than a principle, but it's also fairly well established, despite, and I will get back to that, a number of very problematic aspects. And others are fairly new and quite elaborate formulations, quite long, some of them, So there is this aspect of being a non-systematic provision, and so each of the elements, there are quite a number, would need to be really assessed and discussed, not only in the context of the provision, but also in and of itself, because they have different histories, and some of which has been very controversial, has already been mentioned, and some are rather new, and so it will require a different type of effort in terms of establishing the meaning of the particular principle approach and its potential role in the context of the BBNJ agreement, and the purpose of these articles is to guide parties towards the achievement of the objectives of the agreement. So this is the general role of this article, but it is not this article as a general principle article and something that may be shared with preambles that don't have a direct binding force. Okay, so what John Daspremont would call this a soft negotium. Okay, so a soft part of a binding agreement that provide guidance but doesn't contain any direct guidance for the behavior of the parties. So it's like a meta provision. But we need to find some ways to make these sort of provisions operational in order to not let them be just a declaration of intent. And in my experience in international environmental negotiations, those sort of provisions, they often host things and principles and ideas that don't manage to make it into the operational part, and so it remains like a bridge in between wish and the actual capacity to find landing zones. But it is important, I think, to really make exercises and really strive to make them operational. And I think that one way, at least for me, this useful way to go through that is to really make this exercise, and I want to try to do that in relation to one of this principle. But the baseline or the starting point is to maybe also recall a useful difference, useful for me, between interpretation in the strict sense, and then that respect Kentaro mentioned how those principles would maybe not be so useful for interpretation. But I would distinguish interpretation in the strict sense, which has as objective the enucleation of precise meaning of a provision and of norms already expressed in a treaty text, for example. And what is often called as interpretation in a broader sense, often called juridical construction, which is, I would say, a normal operation most jurists do, which has a different sort of different types of outcomes, such as balancing or, importantly, enucleating norms that are not explicitly included in the treaty. And they come from the combination of the resources that exist in the treaty, precisely through, among others, the deployment of this principal resources that should guide the interpretation and understanding of also the operational parts of the agreement. And I want to kind of continue in this vein, but with reference to one in particular, and maybe if I have time, I'll pick up on another couple of points, and that's the ecosystem approach, given in particular the fact that I've worked quite a bit with this concept. So it seemed natural to focus on this, and Kentaro in particular has already mentioned some important points in terms of the integrative role that the ecosystem approach, but also other of the principles such as integrated ocean management may have, and I will continue along those lines and elaborate a little bit further. But I had to take a step back first because of two things. First, because maybe this is already an acknowledgement of the problems I'm going to solve. The formulation in the article is at letter F, an ecosystem approach. So it's in the terminal. And then I think it captures very well the fact that the ecosystem approach exists in many forms, in different regimes, and that also has been already mentioned. It takes different forms that are not only different in terms of details or operational aspects, but also in the very, in a way, philosophical orientation that it may take. We have heard yesterday references to different mindsets and ecocentrism, and the ecosystem approach is one example where precisely these sort of tensions between traditional resource-oriented conservation and a more, let's say, forward-looking type of conservation, which is focusing more on the ecological dimensions rather than the, let's say, sustainable use. And here we go back to the tension highlighted by Kurt. It's a prime example, and so you will have, just to pick up two easy examples, the ecosystem approach, which has been elaborated within the Convention on Biological Diversity, which tends to generally have a conservationist, holistic foundation, whereas in the context of fisheries, the ecosystem approach to fisheries, it's much more closer tied to traditional resource management as acknowledged by the FAO itself, which have in fact made a study precisely to distinguish these various understanding of the ecosystem approach. And so on the one side, an ecosystem approach could represent a really ecosystem-oriented governance that takes ecosystem as the foundational unit within which governance frameworks should operate. And on the other, as a methodology to optimize the development of resource bases in a way that remains available over time, so with this idea of sustainability, but still with the view of optimizing resource extraction, which is consistent with the framework that is operational in the context of UNCLOS with regards to conservation of marine living resources. So, having said that, what's the outcome? The outcome is that, of course, one needs to do quite a lot of work to understand in this particular respect how one can bring forward and try to operationalize this particular concept that is already at the outset complex and ambiguous and may be drawn in different directions. So here, of course, there is a measure of preferences in terms of how one articulates the notion of ecosystem approach. Some can be gleaned from looking at the negotiating history, although there has been fairly little controversies in the inclusion of this principle from very early on. It's been one of the few that has stuck rather quickly. Unlike others. But generally there is there's a few common elements that can be used to ground a little bit the principle, which I refer to as 4 I's. So there's the first element, which is the concept of ecological or ecosystem integrity. This is a fairly common inclusion in most of the concrete articulation of the concept. And it's also picked up in some of the provisions in the BBNJ agreement, but in the preamble, in connection with the stewardship dimension, but also in other parts of the agreement. And so the integrity provides and offers a significant grounding in terms of the conservation orientation that one may want to draw out of the inclusion of this principle in Article 7. The second aspect, and again here picks up on what Kentaro has already said, is integration. And so the ecosystem approach tends to bring forth this integrative element across a number of levels. Integration in terms of the spatial dimensions, integration in terms of institutional frameworks, integration in terms of the knowledges, that are at play, and integration in terms of the jurisdictional fragmentation that is, as we've seen and as we all know, a key feature of ocean governance, especially in areas beyond national jurisdiction. And so these are potential resources that can be brought then forward when one tries to do what's going to be the last point of what I want to do, is to link the concept with some of the operational parts of the BBNJ agreement. That's the other two I's, refers to information, which would be knowledge, and, and to iteration. Okay, so it's an iterative aspect of the ecosystem approach, which is a key dimension in order to respond to the effect of implementation of policies, to the generation of new knowledge, and so on, and so forth. The next step in this exercise is to then think, on the basis of these considerations, how the ecosystem approach can really be connecting with the operational parts of the agreements. And now we'll primarily look at part 3 and part 4, which are the immediate candidate, in the sense that ABMTs and marine protected areas in particular, in other contexts, are one of the crucial tools that are necessary for the implementation of the ecosystem approach. Ecosystem approach is also mentioned specifically in some of the provisions, in particular in regard to monitor and review. So there is a direct connection, and then that can create like a connecting tissue that may then deploy the resources that are contained, that can be drawn out of the concept and in its location as a guiding principle for the further operationalization of the concept, but also, to use as a guidance for the achievement of the objectives of the treaty. But maybe the most interesting connection relates to part 4, and in particular with Article 39, related to strategic environmental assessment, both in relation to strategic environmental assessment as such, but also in relation to the role and the definition of the tasks of the bodies, both the scientific and technical body and the COP, with regards to development of standards and guidelines that should develop the strategic environmental assessment. And so here we come with another aspect which, albeit in different ways, remains a grounding factor in terms of articulating and then implementing an ecosystem approach, which is the spatial dimension. And so the key here would be to really utilize the example of other fora and maybe even directly link to that, and it would be easily framed within the powers and competencies given to the bodies, and then develop in the same direction a particular sort of understanding and articulating of space for then developing strategic environmental assessment in relation to regions or areas, and also grounding this ecosystem approach in relation to this spatial dimension, which is fundamental for an ecosystem-based management. One example is, for example, the work that's been done in the context of the Arctic Council, which have done a lot of work to develop their version of the ecosystem approach. And to that effect, they have developed a detailed map of large marine ecosystems that provide the spatial unit within which the ecosystem approach can then be implemented. And a similar effort could be introduced through the development of this guidance in terms of the role of these bodies, and then be utilized in order to anchor the development of strategic environmental assessment on the basis of this large marine ecosystem or similar ecologically grounded spatial foundation that would then allow the operationalization in terms that reflect some of the shared tenets of an ecosystem approach, in the context of the BBNJ agreement. The time is running up, so I think I will leave it at that, and there will be other opportunities, obviously, to further consider this sort of operationalization through linkages within the text of BBNJ agreement, but this is what I will have to be satisfied with for sharing these views. I don't have time to circle back to the other point about common heritage, so I will just have to, if anything, share my views over coffee. Thank you very much.
Thank you very much, Professor De Lucia, for providing us with another invaluable perspective and observation, especially with regard to strategic environmental assessment. And our last speaker, the second discussant, is Ms. Mary-Elisabeth Hyoung. Ms. Hyoung is Deputy Senior State Counsel at the International Affairs Division of the Attorney General's Chambers in Singapore, where she advises the government on all aspects of public international law, including the law of the sea, international environmental law, and international dispute settlement. She has represented the Singapore government in various international negotiations, including in relation to BBNJ, climate change, and cybersecurity. And last but not least, she was formerly a fellow of the International Tribunal for the Law of the Sea. Ms. Hyoung, the floor is yours.
Thank you very much, Judge RHEE, and I also want to start by thanking the organizers and our host, the Ministry of Foreign Affairs of Korea, the Korean Society for International Law, and of course also ICLS for what has really been an excellent event, and also for inviting me to be part of such a distinguished panel. Vito has focused his comments on principles, so I intend to focus my comments on dispute settlement. And I intend to discuss them within a broader framework of compliance under the agreement. So the first issue that was raised by Kentaro during his presentation earlier, and that I would like to discuss, relates to the relationship between the implementation and compliance mechanism under Article 55 and dispute settlement under Part 9. The implementation and compliance mechanism was actually something that the Singapore delegation worked on very closely with CLAM, the Core Latin American Group, as well as PCIDS, the Pacific Small Island States. So I thought I should just share some personal thoughts on the issue. So first of all, I agree with Kentaro fully that dispute settlement is but one of several available cross-cutting mechanisms in the agreement that support compliance and implementation. I wanted to just add that in addition to Article 55 and Part 9, there is also the availability of recourse to an advisory opinion from the ICLS, which also is part of this system of cross-cutting mechanisms for compliance. And I'm referring specifically to cross-cutting mechanisms because, as we've heard from the previous panelists in previous sessions, there are also specific mechanisms which also facilitate implementation of and compliance in the specific substantive chapter. So, for example, the ABS committee in the MGR's part, or the CBTMT committee in the CBTMT part of the agreement. So what I'm talking about is mainly the cross-cutting mechanisms. So the three cross-cutting mechanisms that are on this slide, they all serve very distinct functions, but I would say that they are very complementary. So Part 9 has been covered, I think, quite thoroughly by both Kentaro as well as Kurt. It is an adversarial proceeding, and it is how states would enforce obligations against one another. On the other hand, the other two mechanisms that you see they both fall under the purview of the COP. And under Article 47, the COP is empowered to request an advisory opinion from the ICLS And this is a power that they have with respect to legal questions concerning whether proposals before the COP conform to the agreement. So I think we've heard from several speakers, including Professor Kang in his opening remarks, as well as many of the preceding panels, that many of the substantive issues have been left for the COP to decide in the future. And this includes some of the more controversial aspects, including legally controversial aspects, that parties were not quite able to fully agree on. So having this avenue for clarification on legal disagreements may prove to be a very useful and very important tool to have. Then there is, of course, Article 55, which sets out the Implementation and Compliance Committee, which deals with implementation and compliance by states on both an individual and a systemic level. So this is quite different from dispute settlement in a number of ways. First, it is quite clear that the Implementation and Compliance Committee is intended to function in a way that is non-adversarial and non-punitive. So it is not supposed to have the same aspect you would see in a Part 9 proceeding, where states would likely be defending themselves against potential responsibility and liability. The second aspect is that the members are elected by the Conference of Parties and they report back to the Conference of Parties. So the details of the precise procedures are yet to be determined, but I think what we can expect would be something more of a facilitative process, where the Implementation and Compliance Committee would seek to identify, for example, the source of non-compliance or the reasons for non-compliance to help a state or a group of states, if it turns out to be a systemic issue, to try to bring their conduct into compliance. So specific examples that I think were mentioned during negotiations and that received pretty wide support include a scenario where, for example, the Implementation and Compliance Committee could assist to identify solutions, including capacity building needs of a state that has some issues with implementing certain parts of the agreement. And the last paragraph, paragraph 4, explicitly refers, paragraph 4 of Article 55, explicitly refers to the fact that the Implementation and Compliance Committee can draw from information from other subsidiary bodies. And I think the intention is also to allow them to link up with these other bodies, including, for example, the CBTMT Committee, in order to find ways to satisfy or help states with their capacity building needs. So this is just one example. Another aspect that actually came up in my very fruitful lunchtime discussion today with Professor Eliza Morgera is that actually there is potential for the Implementation and Compliance Committee to have an interdisciplinary sort of composition. So this will then distinguish it further from what you would see in an adversarial proceeding where you have a group of judges making a decision, and this would be more a group of members with different competences and different expertise that will be able to help states bring their conduct into compliance. So essentially, although some of the details remain to be worked out, I think it is quite clear, at least in the minds of the negotiators, that these three mechanisms are supposed to operate in a complementary fashion and serving very different functions. I also thought it would be useful to just take a step back and to look at the kind of systems of compliance that we see in multilateral environmental agreements preceding the BBNJ. This list is, of course, non-exhaustive, and it is just intended to just show some trends when it comes to these compliance mechanisms. So in the second column, what you see is that states have, under previous agreements, which did not establish standing implementation and compliance committees, started establishing these committees several years after the treaties entered into force because they identified that there was this need. And then I think it was it started around the time of the Cartagena Protocol, which was one of the early treaties that had a provision that provided for it didn't explicitly establish an implementation and compliance committee, but it included a provision that directed the COP at its first meeting to approve a compliance mechanism. And then we have Paris, and then the BBNJ agreement, where the implementation and compliance committee was established in the agreement itself. So you can see just from this column that really the later agreements, including the BBNJ, draws from the experience of the other multilateral environmental agreements that preceded it. In the next column, well, the next two columns actually, maybe I'll talk about the last column first. What it shows is that compulsory binding third-party dispute settlement is actually still very exceptional in multilateral environmental treaties. And it is really only UNCLOS and the UNCLOS's implementation agreement, the UNFS Fish Stocks Agreement and the BBNJ agreement, that have recourse to compulsory binding third-party dispute settlement. For most of the other multilateral environmental agreements, what we have is most of the time either no binding dispute settlement or a sort of opt-in provision. And with respect to the agreements, where I've put a little star, these are opt-in agreements, and in the event that the state did not opt in, there's compulsory conciliation. But of course, that doesn't result in any binding outcomes. So overall, I think the regime in the BBNJ actually benefits from both the experience from other multilateral environmental agreements, as well as from just being an implementation agreement of the UNCLOS that has the benefit, of compulsory dispute settlement, but also the ability to have recourse to the ICLS, because it is an agreement related to the purposes of the law of the sea. So another interesting issue that was raised is whether, I think it was towards the end of Kentaro's presentation, whether Part 15 UNCLOS is necessarily the most appropriate dispute settlement for the BBNJ. And I think Kentaro talked about this a little bit. I just wanted to elaborate. I think for the states who supported the application of Part 15 UNCLOS, one of the main considerations is the fact that the BBNJ agreement is an implementing agreement of UNCLOS. And as was discussed, I think, by many of the speakers before, including Judge Baek in his keynote, and also the sessions on ABMTs and CBTMTs, a lot of provisions under the BBNJ agreement are actually implementing or reinforcing existing UNCLOS provision. So because of this, it seemed to be the cleanest and most straightforward approach to apply Part 15 of the UNCLOS, and that would hopefully then also avoid unnecessary procedural issues when you have conflicting jurisdictional issues. This being said, I do agree with the point that was raised, that there are likely to be types and nature of disputes under the BBNJ agreement that would be different from what we would usually see in UNCLOS dispute settlement. And this was actually one of the reasons why the proponents of Article 59, which includes Singapore, El Salvador, Colombia, as well as the Philippines, yes. Why we supported including a provision on technical disputes. And although it's not possible to predict all possible disputes that may arise, I also wanted to highlight again Article 58, which would still allow states to tailor the dispute settlement mechanism, provided they can agree, to suit the nature of their dispute. One last issue that I thought maybe I can briefly comment on that Kentaro raised was that there may be some issues that involve, I think the word he used was infringement of community interests that may not be best addressed by Part 15. And I'm just reflecting, I think maybe one way to deal with interests which are of a collective nature may actually be through the multilateral process of the COP. So dealing with it in a collective manner as well. So this is not precluding, obviously, dispute settlement under Part 9, which will still apply, but there may be disputes or disagreements that could be maybe best addressed either by the Implementation and Compliance Committee or through an advisory opinion by the ICLS. The third and last issue that I thought I would talk about relates to Article 60, Paragraph 9. So Kentaro raised a lot of interesting issues. I will not comment on every single one of them, but I think one interesting point he said is that it relates to the proviso that nothing shall be interpreted as limiting the jurisdiction of courts and tribunals under Part 15. My personal reading of that provision is that it is intended to preserve the room of courts and tribunals that are presently exercising jurisdiction under Part 15 to continue developing the jurisprudence that has been ongoing for some time regarding so-called mixed disputes, so disputes involving incidental issues. So the intention is to ensure that the rest of paragraph 9 isn't interpreted in a manner that would somehow preclude or constitute subsequent practice that will prejudice that developing jurisprudence. So that's my own personal reading. But I would say that it is perhaps open to interpretation how this proviso can be read and applied. Another issue, as he was discussing the potential impact of previous decisions on issues arising for concurrent consideration, what came to mind was actually the decision of the special chamber in the delimitation between Mauritius and Maldives. I think during the preliminary objections phase, the special chamber took into account the previous advisory opinion of the ICJ. Obviously, they did so in a very contextual manner, taking into account also the state practice and the UNGA resolutions before and after the advisory opinion. But I just thought that perhaps some parallels could be drawn from that case that could be useful when you consider this issue. I also reflected Article 47 because I thought that it would be, I just wanted to point out that it includes actually the same language that you see in Article 60. So with my remaining 3 minutes, I just wanted to make my concluding point, which is similar to, I think, what some of the other speakers have said. I think the BBNJ shouldn't be seen as a sort of panacea to all existing problems arising under UNCLOS, RFMOs, and MEAs. It can't resolve issues that have arisen and can't be solved under those treaties. For example, the BBNJ agreement is probably not the best suited to deal with territorial sovereignty issues. But I think the best description for the BBNJ agreement would be a springboard, which provides us with momentum to kind of move forward. And it does so by identifying and setting up mechanisms and roles of different bodies and players that can collectively, I think, provide for a fairly solid regime. And I think the other speakers have mentioned, I think it was Professor Mossop yesterday and also Dr. Sarah Lothian today. They explained how also other bodies outside the BBNJ regime have a role to play. And I also wanted to just recall, earlier this year, Ambassador Reina Lee was asked how she would describe the BBNJ agreement, and she described it as an agreement of possibilities. And I actually fully agree with that because the conclusion of the BBNJ agreement is really only the conclusion of Chapter 1 of the BBNJ story. So how we move forward really depends on how states and other stakeholders choose to operate and set out and detail the other mechanisms and the provisions under the BBNJ agreement. So on this very optimistic note, I would like to conclude my remarks, and I thank you for your kind attention. 감사합니다.
Thank you very much, Ms. Hyoung, for sharing your bird's eye view, comparative context with regard to dispute settlement mechanism with us. And from ICLS's point of view, I'm grateful that you refer to the advisory opinion. And I also invite other speakers and discussants to share your take on advisory opinion provision in Article 47, paragraph 7, if you wish. Before opening the floor, I'd like to give a couple of minutes to the speakers to respond to what has been raised in the discussion. So, Mr. Davis.
Thank you. I really appreciate the elaboration that was made of the other, if you don't want to call it non-combative options. Bearing in mind, of course, the agreement requires states to choose peaceful settlement of their disputes. And in that vein, the question of the advisory opinion option does appear attractive because it would give, that external perspective on a particular matter. Experience, however, tells us that the determination and decision to seek an advisory opinion is often itself quite a disputed, what would you call it, question or decision to be taken. So, and in fact, in the negotiation, the inclusion of the option to seek an advisory opinion was itself, subject of much back and forth and dispute. We managed to win it over into the text in the end. But I suspect that even in that case, the conference of parties in taking a decision to seek an advisory opinion, it would be quite, a contested decision, likely to be subject to much controversy and voting. But, if it leads into a non-political outcome to give guidance to the states parties, then that is, of course, a positive way of helping to resolve what could be considered as problematic.
Basically, I would like to thank the other two discussants for engaging with my presentation in the way they did. And I think my presentation and what was discussed was really complementary to each other, so I really appreciate that. Just a few comments, and with regard to Vito's comments, I really appreciated your suggestion that the process of interpretation could be more analytically divided into interpretation in strict sense and interpretation in broader sense. And I think that will really help to further explain how the principles which are supposed to guide the parties will be helpful in identifying what would be the course of action for the parties, and what are the implications of the principles and approaches that are contained in that Article 7 for the entire agreement. And on Mary's comments, thank you very much for addressing many of the rather complicated issues. I especially appreciated your slides on the MEAs, the institutions that are available for different MEAs, And I guess the basic point that I was trying to maybe discuss in that part of my presentation was that I think the conventional understanding was that for multilateral environmental agreements, it would work better not to have maybe a sort of a adversarial dispute settlement, but rather it would be helpful more to have a system that focuses on non-adversarial facilitative functions. But I think what we have in the BBNJ agreement, because it's a mix of course, environmental and a mix of maybe traditional law of the sea, we have a rather unusual setup where we have a compulsory dispute settlement, which is completely adversarial, but then we also have another element that sort of we inherit from the experience of multilateral environmental agreements, that we have a compliance and implementation committee. And so I think we did have sort of an understanding of the different ways in which the different components can work together to ensure the effective operation of the agreement. But I was wondering whether this unusual setup may or may not give rise to maybe questions that needs to be further asked about how the different components would really work in the context of maybe different issues arising under the agreement. And also thank you for your reference to the Maldives Mauritius, the decision from the ICLS. I think that was also actually something that came to my mind, where the Tribunal looked at the advisory opinion from the ICJ on the Chagos Archipelago, and consider that due to that advisory opinion, there is no longer a dispute between the two parties. And I think the point that was made was that a mere assertion does not give rise to a dispute under international law. On the other hand, I think one maybe caveat, maybe in sort of trying to build on that decision, is that as I read the decision, the reasoning seems to be very much focused on the fact that this was an advisory opinion from the International Court of Justice. And I feel that there may be different considerations if we take into account maybe the preceding judgments or awards from other international courts. So there may be some similarities, but maybe also very important differences in that regard as well. I think I should stop here. Thank you.
Thank you. And now we have about 10 other minutes, and you are kindly invited to make comments and raise questions. Judge Beck.
Thank you, Mr. Chairman. I want to make two observations. First, unlike most of you here, I have never participated in BBNJ process, whether it is negotiation or discussion. For most of the time of BBNJ process, I have been judge of ICLS, so I had no opportunity. The only time I was engaged in BBNJ process indirectly or remotely was when I was president. That was from 2017 to 2020. At that time, BBNJ Intergovernmental Conference has just started. At the Tribunal, we were interested in what would be the dispute settlement system of new agreement. So we followed the negotiation. And then I considered that it would be helpful to negotiating states if I could offer my observation in my capacity as a president of Tribunal. So I made a statement in the state parties meeting and the General Assembly with respect to dispute settlement system. I don't remember what I said at the time, but I think I made 2 or 3 points. The first point was exactly the point raised by Kentaro. I remember that I encouraged delegates to consider and design the approach or dispute settlement system that could best address the type of dispute that can be expected on the new agreement. That being said, of course, I fully understand that BBNJ agreement is supposed to be implementing agreement of the convention. Therefore, as Mary-Elisabeth mentioned, states have general tendency to look at the dispute settlement system of convention. But Part 15 is not the only dispute settlement system of the convention. In fact, there is another dispute settlement system for activities in the area, which was contained in Part 11, Section 5, seabed dispute chamber, and so on. There's a very different dispute settlement system. So even convention has multiple systems of dispute settlement. So I encourage delegates. We had a side event, and I encourage delegates to consider many options, many different options. One thing we had in mind at that time was this choice of procedure under Article 287. Obviously, this choice of procedure was a product of the time, 1970s. Many socialist states, including Soviet Union, was strongly opposed to this adjudication. They had a preference for arbitration. So 50 years later, whether this would be the best, most appropriate model for BBNJ to consider. So that was the point I raised. The second point I raised at that time was this advisory opinion. I encourage delegates to consider requests for advisory opinion. As you may know, in 2015, the Tribunal already affirmed that it can give advisory opinion. Full Tribunal can give advisory opinion. Therefore, I encouraged this considering such option. But now, as it turned out, I realized that I was not very persuasive. We have this Part 9, and advisory opinion was adopted, but in a little bit diluted way. But anyway, that's what it is. But like many other things, this dispute settlement system has also its own life. So we will see how it will evolve in the future. That is the first observation. The second observation I want to make it related to this non-adversarial approach to dispute touching upon community interest. Here, we can see the trend that in international adjudication, this traditional notion of standing, requirement of injury, have become less relevant with respect to breaches of obligation erga omnes partes. This is happening with respect to especially breach of human rights. Tribunal ICLS has never faced a case in which such issue of standing arose so far. But as you may know, in case of International Court of Justice, since this dispute between Belgium and Senegal, we see case after case where standing doesn't matter, you know. We have this case in which Gambia took legal action against Myanmar, and lately we see, I think, Netherlands and Canada started legal action against Syria, and also it is expected that another European country considers taking legal action against Afghanistan and so on. Now, with respect to BBNJ, I don't know, but there seems to be several obligations erga omnes partes. If dispute arises with respect to alleged breach of such obligation, I'm wondering whether we see similar trend. Non-adversarial approach to dispute touching upon community interest, that's fine, but what will really evolve in the future may be a little bit different from that. But we will see again how it will evolve in the future. Thank you.
I feel like that I have to say I'm sorry. And also, thank you very much for sharing your insights with us. And does anybody would like to respond to the comments made by Judge Park, or we have time for maybe one question? Is there anybody to make any question or comments? Lydia Soto. Yeah.
Thank you. Thank you to the distinguished panelists, and also thank you to the discussants. My question is regarding the advisory opinions, that they were reflected as an open door, to put it very bluntly, a gradual open door before compulsory jurisdictions or adversarial formats of dispute settlements. But what could be the role of states, and what could be further enhanced from developing states with regards to inputs that are provided to those advisory opinions, and particularly with the future mechanism or the future implementation of the agreement in that regard? That's from one end, that was a question. And the second is just a comment. It is true to what Professor Nishimoto reflected on, how sometimes the political sensitivities could affect the negotiations and the dispute settlement. But I think the BBNJ, and as very accurately reflected by Ms. Chong, does provide that open door of how can we start to take note of the progressive character of international law when referring to dispute settlement by resorting to this technical nature dispute settlement formats that do correspond to the nature and multidimensionality of the agreement. And that also helps, for example, to certain parties to take on board the discussions on whether there are progressive mechanisms that could be reached to before a compulsory mechanism. Because another complexity of resorting to a compulsory jurisdiction is also the need to assess to the parties that are within the dispute the type of resources that these parties have within the hearings or the different forms of litigation, and which, of course, all of this together is very asymmetrical in comparison to, for example, countries that do have their own representatives and do have major capabilities to handle this dispute. So I think when we start to consider in a progressive character other types of formats, does provide more inclusivity for parties, and particularly those developing, to be part of that dispute settlement out of in good faith and to fully comply with the obligations of the agreement. So I do want to end up with, and I do share your positive note, that despite it could be criticized, but we could have shortcomings, but we could also have more inclusivity and more engagement. So just that. Thank you very much.
Okay, I believe you are not requesting any response from the panelists, right? Yeah. So I believe this brings us to a close of this final session. And I'd like to express my sincere gratitude to the wonderful speakers and discussants. But before closing, taking advantage of my capacity as the moderator of the last session, I'd like to express to all the panelists and the participants in this conference, I believe there is a general consensus that for the past 2 days, we have been served very sumptuous meals, not only physically, but also mentally. Almost 2 decades of discussions and negotiations have been condensed to a 2-day course meal, exquisitely prepared by top-notch chefs. That is, I mean, key players of the negotiations and also authoritative commentators in the area. And what is better, without sleepless nights. I cannot agree more with Lisa that we have to double our efforts to make the agreement enter into force as early as possible. Some of you might recall that Korea was one of the countries that advocated for 30 countries as the requirement for the entry into force of the agreement rather than 60. Given the scale and speed of deterioration of our marine environment, we have no time to lose. When you think of the burden imposed on COP, especially the first COP meeting, to deal with a number of hard and controversial issues, we cannot rule out the possibility of having a resumed or even further resumed meeting of the first COP. We should not be complacent about what we have achieved, but have to prepare for the entry into force of the agreement in the first COP meeting with a sense of urgency. Every channel of communication, discussions, and educations must be kept busy, just as if we are still in the process of negotiation, because it is the reality. Finally, since I am one of the participants in the 3-year navigation to the law of the sea for the next generation, I'd like to express my deep appreciation to all 3 organizations of the series for the successful completion of the mission. While believing we share the idea that it is time to move from reflection to action for the generation to come, I wish you all happy evening, happy stay, and safe return to your place. Thank you very much.
Thank you. Once again, please give a big round of applause for all the speakers on the stage.